Hello, everyone. Thank you for joining me this evening. I'm super excited that you guys decided to participate in this webinar. So tonight we are going to be talking about trust and how to set up a trust, okay? So the different components of a trust and how you can actually use a trust in order to build wealth. So let's get started. And then, so I'm going to go through the presentation. It's going to be about 1 hour. And then after that, you guys can ask questions, okay? Let's see here, boom. All right. So welcome to the Wealthy Trustee program. In this program, you're going to learn about how to set up a trust and the different contributors in the trust. Okay, so this is the right way of building wealth if your mission is to build generational wealth. Okay, if you're just coming in, please mute yourself because if you are off of mute, it's very distracting. Okay, thank you so much. Let's see. Good. All right, there we go. All right, so I'm going to be your instructor today. My name is Christina Ivette. I am a passive income strategist. So I've helped hundreds of people create passive income, either with their trust or just them individually. And I have been a trustee since 2015. I was a nurse by trade. I was a nurse for about 8 years. And my second year in nursing, I started saving up my money so that I could create a business and create passive income for myself. And so my first asset that I acquired was a property that I flipped. And this property, I actually purchased it with a trust. So that was my introduction into using trust entities, was as a real estate investor, because I knew that I was young, 25, female, and anything could happen with this new business that I was creating, as well as the property, right? Because construction was happening, you had subcontractors, somebody could step on a nail or get injured. So I couldn't put myself in a liable situation to where someone could actually, sue me and take my property. So somebody's off of mute. So I put the property into a trust. So with that being said, that was my introduction into becoming a trustee. So what I want to do is I want to show you guys my structure. So you guys can see that.
Stop hiding from my stuff.
Hold on 1 second. Let's see. If you're off of mute, can you mute yourself? There we go. I found it. All right. So this is my real estate company. And if you scroll down, you can see that it's owned, the authorized member is Urban Holdings, Inc., right? So if you go up here and you search Urban Holdings, then once you get to Urban Holdings, you're able to see, if you scroll down, you're able to see that the chief executive officer is Ways to Wealth. So Ways to Wealth is actually the name of a trust. So the trust is the owner or the shareholder of the holding company, okay? So I just wanted to show you guys my structure so that you can see, an example of what I'll be showing you guys today, how you can get restructured to protect yourself so that you're not the owner of your business, okay? So quick disclaimer, this is not legal advice that I'm giving you guys. This is also not tax advice. So I'm not a licensed attorney or a certified public accountant. I am a trustee. I've been operating a trust since 2015. So I'm just giving you guys insight to what it is to be a trustee and how to actually operate a trust. So the objective of today is for you guys to learn what is a trust, who are the contributors, how to operate a trust, some tax strategies that you can use to reduce your tax liability down to zero, some wealth strategies that you can use in order to build wealth, and how you can protect your assets, okay? So you have some companies here. These companies are billion-dollar organizations. You have Amazon, Berkshire Hathaway, and Trump. So these companies pay literally no taxes, or very little taxes, right? For example, Berkshire Hathaway is owned by Warren Buffett, and Warren Buffett publicly said that he pays less taxes than his secretary. So how is he able to do that? Well, he's able to do that because he uses a trust within his structure. He has, a for-profit arm, a nonprofit arm, and then he uses trust within his structure. So if these businesses are using trust, then you should also be using trust as well in order to reduce your taxation and in order to, to build wealth faster.
That means I want you to come. Why don't you come away? I am.
Okay. So I have a $1 bill here, right? The Federal Reserve note. So does anybody see the word trust in this $1 bill?
Yep.
Perfect. So you do see the word trust, right? So when we are like out here in society, right? When you are talking about a trust, you're talking or using the word trust, you should be using it when you're talking about an entity, right? So in God we trust is an entity. It is an actual trust that the United States uses, and the United States is a corporation, okay? So they use trust within their structure as well. And if you have a Social Security, or if you have a Social Security card, or if you have a birth certificate, then the United States has also created a trust for you. And trust is a sister-Q trust, and that trust is tied to an insurance policy. So that's how you are able to get, benefits like free education and, and Medicare and all of these.
It's okay.
Social Security and things like that.
Come on.
All right. Can you please mute yourself? If you're not on mute, can you please mute yourself? Thank you. So let's dive in, guys. So what is a trust? A lot of people, they hear the word trust and they're not familiar with what a trust is. So a trust is an entity. A trust is what we considered a living, breathing entity. So it is just like you. You are a living, breathing entity. You are a human. And so a trust is actually seen out here in society as an individual, okay? So you as an individual, you pay taxes, right? You pay, you file a 1040. And the trust as an individual, they also pay taxes, right? The trust files a 1041. So they are seen equivalent to you. So everything that you can do as a human, a trust can also do. So if you can build credit, a trust can build credit. If you can write a book, a trust can write a book. If you can purchase a house or a car, a trust can purchase a house or a car. So there's no limitations when it comes to this type of entity. This entity is very powerful, okay? So a trust, like I said, is an entity. It is actually a contract, okay? That is what you're going to be creating. You're going to be creating a contract, and this contract is between several different parties. The parties involved are a grantor, which is the creator of the trust, a trustee, which is the fiduciary or the individual that's going to be managing the trust on a day-to-day basis and operating it, and then a beneficiary, which is the heir or the individuals that will be benefiting from the trust, okay? So when we're talking about this specific contract, we use the word indenture. Indenture means agreement, so it's equivalent to contract, okay? So trust, it falls under contract law, which is the highest form of law in this country, okay? So we're talking about a contract. So your trust has a declaration of contract and it has an indenture. This trust, it can be used, it can actually like represent you in whatever endeavors you want to do if you use the entity the right way. So you can actually use a trust in order to operate privately and not be exposed to the public anymore like how you are now, right? As an individual right now, you are putting your first and last name, you're jotting down your social security and things of that nature, not knowing that that you're liable for whatever contracts you're putting yourself into. So everything that we do is a contract. For example, you live in a house or you live in an apartment. You have a contract in order to live in that place. You have lights on in your house and you have running water. You have a contract in order to have running water and electricity in your home. You go to a school or your children go to a school. You have a contract with that school in order for your children or yourself to attend the school. Everything that you do, even your employment, is a contract. So you as an individual, you have been dealing person to contract, right? Person to entity. And now if you empower yourself and actually create a trust entity, now you can deal contract to contract, okay? So it's extremely powerful. If you're off of mute, please mute. It's extremely powerful that you are using contracts when you are dealing here in the public, okay? Because you want what we call obscurity. You want to be able to conceal your identity. You don't want yourself on public records and for anybody to just, be able to, pass by your house, right? Or knock on your door, things of that nature. So the contract, it's created by a creator, right? By the grantor for the benefit of someone else. So that's for the benefit of the beneficiary, and it is controlled by the trustees. So those are the individuals that are going to be participating in this contract. So let's go through those specific contributors. So who are the parties involved? Like I said, you have a grantor, which is the creator. So another name for grantor, you're going to hear these names if you are dealing with trust. So another name for a grantor is settlor. Another name for a grantor and settlor is trustor. So you're going to hear those names interchangeably and just know that they're talking about the creator, okay? And so what does the creator do? The creator is the one who's actually initiating the trust creation, okay? So they're the ones putting the provisions in place, the rules, the regulations, the bylaws in order to be able to have this entity formed, okay? Then they are going to appoint a trustee. The trustee is the individual who's going to control all the assets in the trust. They are the individuals who are going to operate the trust on a day-to-day basis. They are the individuals who are going to acquire assets for the trust. So they're the ones who are going to be doing the buying and the selling. So if the trust owns a home and the trust wants to sell the home, then the trustee is the authorized signer that's going to be selling that home or putting it on the market, selling it at the closing table, okay? So that's what the trustee does. They are a fiduciary and they're acting in the best interest of the beneficiary, because the beneficiary is what we call the inheritor, right? So the beneficiary is the individual that's going to be inheriting all the assets once the trust is terminated. So one thing about a trust is that it has an establishment date as well as a termination date, okay? So the establishment date is what we also interchangeably call the birthday, right? Because there's going to be certain paperwork that you're going to be filling out, and it's going to, you know, be applicable for like a human or an entity, right? And so it's going to say birthday, and because you're putting the trust information, you're going to put the establishment date of the trust. So if you were actually creating the trust today, then today would be the establishment date, okay? So one thing about a trust is that a trust has a termination date compared to an LLC or a corporation where they don't have any termination date. They are, if you're off of mute, please mute. Thank you. So you have a termination date, right? So the date is whatever day you choose. So you can choose to operate your trust whenever you want or however long you want. But the minimum in this industry, we tell you to operate your trust is at least 7 years, right? At least operate your trust for 7 years. And then you also want to, you know, you can also operate it for a maximum of 100 years. So it just depends on you, but just understand and know that the trust is going to outlive you. So if you are creating generational wealth, then you want to be able to, you know, to put this termination date for as long as possible. Hold on one second. I have to mute somebody. What is the deal here? If you're off of mute, can you please mute?
Kendall and Sonia are unmuted. Please mute.
Where is Sonia?
If you go to participants, it shows me the unmuted first.
It's not
Their
showing.
mic is going to be gray. She just muted.
Okay, thank you. All right, so back to the dates, right? So you're going to operate your trust for anywhere between 7 years to 100 years. Now, once that termination date approaches, you need to renew your trust, okay? Because once your trust expires, that literally means that your trust is dead, okay? We use that type of terminology because this trust is what we call an inter vivos trust. So it is a living trust, okay? Your trust document is a living document, okay? So if you allow your trust to be terminated, then you cannot renew it. So you have to renew it at least 30 to 60 days before it's due. So if you're operating it, if you decide to operate it for 100 years and you're doing it today, then it's going to be, you know, due for renewal May 25th, 2023. Okay. So whoever the trustee is at that time, because you have to understand that the trust is going to outlive you, right? You're not going to last 100 years. Let's just be honest. So whoever the trustee is at that time, that's their fiduciary responsibility to renew and reinstate the trust. Okay. So keep that in mind because once the trust is terminated, then at that point in time, if it's going to stay terminated, then all of the assets that were in that trust, the trustee has to deed them over or change the ownership over from the terminated trust into the beneficiaries. And then you can also decide who gets what. You can put that in the body of the trust, okay? So that's extremely powerful. So that's, the trustee, they have a lot of powers within the trust. And then the beneficiary, they are the receivers of the assets, right? So they are, what we consider they have beneficial interest. So they're the ones benefiting from the trust, okay? So appointed duty. So the grantor, they are the creator of the trust. And so they're going to appoint the first trustee. They are going to transfer any assets into the trust. And that's, optional. And then if it's an irrevocable trust, then they pretty much walk away from the trust. Okay. And if you have and with the trustee, they are going to appoint their successor, right? They are the ones who are going to be managing the assets in the trust, and they're going to be investing the trust funds. So your position, what you want is you want to be the trustee. You want to be able to have full control over your trust, over the assets in your trust. You can liquidate them at any time. You can terminate the trust whenever you want. You can make amendments to the trust, okay? So that's extremely powerful. So you have to choose a successor, and you want to do that sooner rather than later, okay? And how you're going to choose a successor is you're just going to obviously choose someone who can participate or qualifies for the role, meaning that you're not going to choose someone who's a minor, right? You want them to be of age, at least 18 and older. You want them to be passionate about, trust and actually operating, to have some type of, business savviness. And they have to basically not only qualify, but they also have to accept their appointment, meaning that if you appoint them to be the successor, they have to approve it, that they agree to be the successor. And then you want to, because they might not take over for another 15 years. So you want to be aware of that, on a regular basis. So you want to check on the successor every year or two to make sure that they are still able to operate the trust and become the successor when it's necessary. So when would they become the successor? So they are going to be the successor trustee, and they are going to take over in the event that you expire, in the event that you become incapacitated, or in the event that you resign. Then the successor is going to take over, okay? So you have to share the trust documents with them. They have to understand all of the trustee powers in order to be able to manage the trust and to have this position, okay? So that's the position that you want if you want full control over your trust. The beneficiaries, they have no control and no power whatsoever. And they're not allowed to, not within a trust structure, especially like a solidified trust structure that's not like a living trust, okay? And with that being said, if the beneficiaries, if it's found that they have any powers, then that means that you have not been operating a trust. So you need to be very mindful that you don't give any powers to your beneficiaries. So your beneficiaries, their number one duty is for them to understand the trust. So you want to, provide them a copy of the trust so that they can understand that governing instrument, because they are benefiting from the trust. So they should know the provisions within the trust, and they should know the powers of the trustee, because the trustee is acting in their best interest and is their fiduciary. So they should know what the do's and don'ts of the trustee. Okay. So that's very important. And then we have a special position within the trust called a protector. And this position is where the protector is watching over the trustee to make sure that the trustee is dealing legally and lawfully and in their fiduciary capacity, and that they're not stealing from the trust, they're not mismanaging anything from the trust, right? So they're there to protect the beneficiaries from the trustee. So they're going to initiate audits. They are going to, delegate and outsource to like different lawyers and advisors to make sure that the trustee and the accounts and the bookkeeping and all of these things, the assets are, everything is, within order. And so if the protector finds that there's some illegal dealings, then they can either go to mediation, arbitration, or they can terminate the trustee, okay? So if you are the trustee, then you obviously do not need a protector. You don't need anyone watching over you. So you're not going to appoint anyone right now to be your protector, but you want to keep that position in mind for the future when your successor takes over, because you want them to be able to operate the trust efficiently and not cause any negligence to the point that your trust, loses all its wealth. Okay. So, so with the protector, you're not going to appoint a protector right now, but you can do that in the near future. And the protector, once they're appointed, they are going to choose their successor. Okay. So it's going to be a conflict of interest if the future trustee chooses the future protector, because the protector has to be an individual that's not related to you, not related to the beneficiaries. They have to be what we call, an adverse independent individual. Okay. So there's different types of trust. There's irrevocable trust, there's revocable trust, there's land trust, charitable trust, living trust, testamentary trust. So we're going to go through the different types of trust. So the first thing that I want to bring to your attention is implied versus express. So an implied trust, and these are, categories that you can put the trust into. So an implied trust is an oral trust. So you know how you have oral contracts, you can also have an oral trust, right? Where you set it out verbally to other individuals, like-minded individuals, and you have an oral trust. I personally don't recommend an implied trust. Then you have an express trust. An express trust is a written trust. So meaning it's in a contract form, it's written down, black and white, paper, you can actually physically, tangibly hold it, okay? So that's what an express trust is. So then you have statutory versus non-statutory. So a statutory trust is a trust that is created in your state, and that trust has to abide by your state statutes and codes, meaning, and typically lawyers or attorneys, they are the individuals that create statutory trust. So if you decide to go get a trust from an attorney, you have to understand that the attorney is, dealing in legislation, right? And so they are dealing with, they're dealing in a statutory manner, right? So they can only operate in their state. And so they're going to put all the state statutes inside of your trust. And so your trust can only operate in the state that the attorney is licensed in the state that it was created in. Okay. So that limits you, because if you are an investor in Florida and you want to, invest in New York, you won't be able to do that because your trust can only operate, because it's a statutory trust, it can only operate in the state of Florida. Okay. So if you're going to an attorney, that's the type of trust that they're going to give you, a statutory trust. Now you have another type of trust, which is called a non-statutory trust. A non-statutory trust is where this type of trust, it deals with common law. So it deals with the common law, which is the law that was created before the Constitution. So when the states were sovereign, right? And this is like the republic of your state, the Republic of the United States, right? This is before the Constitution, you have the common law. So that is what a common law trust is. And so it's a non-statutory trust, meaning that it does not it's not regulated by the state. That's one. It doesn't need to be registered with the state because it's private. And that's two. And then three is that it doesn't have to abide by the state statutes and codes. So that means that you can actually operate a non-statutory trust in the entire nation, right? Which is a benefit to you because, like I said, if you're an investor and you're in Georgia and you want to invest in California, you can do that. Your trust can operate in all 50 states, okay? So that's an advantage that you definitely want to implement. Another thing is for legal purposes as well, right? So if you have a non-statutory trust, that means that if you go to litigation, a statutory court system cannot carry your case, cannot see your case, meaning that if you're getting sued in Florida and you have one of those, local clerk of court situations, they can't see your case because it's a statutory court system. So you have to go to a higher form of a court system in order to have your case be seen. So you have to go to like the Supreme Court because the court systems in your case, like even the judges, right? Even the judges, the lawyers, they cannot see your case. So sometimes when you're in litigation and they see that a trust is the one who owns the property or owns the business, then at that point in time, some of these lawyers will tell you, I can't even represent you because I can't fight against a trust, okay? So that's to your benefit as well. So now let's talk about revocable versus irrevocable. So those are the other two categories, right? So the other two categories are irrevocable versus revocable. So revocable is where it can be revoked. Let's just, make it simple. So that means, and this is specifically talking about the creator of the trust, okay? It's not talking about any other party. We're not talking about the beneficiaries, the successors, or the trustees. We're talking only about the creator. So it means that a revocable trust can actually be revoked by the creator, right? So the grantor can terminate the trust at any point in time. The grantor can remove beneficiaries at any point in time. The grantor can take back property at any point in time, and the grantor can make amendments to the trust at any point in time. So that is a revocable trust. Then you have irrevocable. Well, let me go back to revocable. Because the trust is revocable, meaning that it can be amended or changed by the creator, it can easily be pierced by any court system, right? By the judge if you go to litigation, because it is easily changed and manipulated, right? And altered. Okay, so that's the way they see it. Now you have an irrevocable trust. An irrevocable trust cannot be changed by the grantor, meaning that the grantor cannot terminate the trust. The grantor cannot remove any beneficiaries. The grantor cannot change or amend the trust. And the grantor has what we call irrevocability, okay? So that's only dealing with the grantor. So if you're the grantor, then you can't take back property. That's what your position is, right? This doesn't apply to the trustees. So if you're the trustee of your irrevocable trust, then you can make amendments to your trust. You can put assets into your trust and take them back out at any point in time. You can, you can make amendments. Like I said, you can change beneficiaries if you need to and want to at any point in time. So you as the trustee, you have revocability, but the grantor doesn't, okay? So with an irrevocable trust, the grantor creates the trust and then they pretty much walk away from the trust. That type of trust is what we call a bulletproof trust. And the reason being is because it cannot be altered and changed by the individual that created it. So if you were to get any type of trust, you would want to get an irrevocable trust, but you don't want the irrevocability, meaning that you don't want to be the grantor in that contract. So you want to assign or appoint someone else to be your grantor, okay? So there's hundreds of different types of trust. So you have to just create, or determine which trust is the best trust for you, okay? So how do you create a trust? Let's go through this list. So the first thing is you need to determine what type of trust you want to create, okay? Other categories within the trust that I didn't previously mention is simple versus complex. So a simple trust is a trust that is one, simple, and two, it is required to do distributions, meaning that you have to distribute to the beneficiaries. A complex trust is one that is, complex, right? And it is not required to do any type of distributions to the beneficiaries. So the trustee has discretion, okay? Other categories that we use within trust is discretionary versus non-discretionary. So what that means is, and we're only specifically talking about the trustee. So if you have a discretionary trust, then that means that you can operate the trust with your full discretion. Okay, so that means that obviously you have a trust is a contract and all the bylaws are there, all the provisions are there, but not everything is listed in the trust. Let's just be honest, right? Something might come up and it's not in the governing instrument. So then what are you going to do? You are going to use your full discretion to be able to navigate and defend the trust at all costs. So that's what we call a discretionary trust, which is the type of trust that you want. You want a discretionary trust. You don't want a non-discretionary trust because with that type of trust, you don't have discretion. If it's not in the contract, you cannot do it, which means that you have limitations and perhaps you're not able to, to defend the trust at all costs, okay? So you want to be operating with your full discretion when you're operating your trust. So once you figure out the type of trust that you're going to create, then you're going to determine the trust name, okay? So you can name your trust whatever you want, right? You can name it after your initials, you can name it after yourself, but it's not advisable, right? Because you're using your trust for protection purposes. So if your name is John Smith and you name your trust John Smith, it's a dead giveaway. And this is a private contract, so you're taking an oath of privacy that you don't have to disclose who the trustees are or
Donna, don't swing that thing.
Can you mute, please? Man, we're struggling tonight with this whole mute thing, guys. I'm sorry. Normally it's not like this. So back to what I was saying. When you are naming your trust, you can name it whatever you want, okay? But don't name it after yourself because it's a private entity and you don't want to be, you want to conceal your identity. So it's not in the best interest for you to name it after yourself. You can name it after your family. You can put your family name into it if you want. So now if you have a business trust, you can also use things like corporation, LLC, company, co, holdings. You can use those things at the end of your, at the end of the name of your trust, okay? Because your trust is, if you have that type of trust that's dealing with common law, then the name that you choose is going to be copywritten under common law. So you can use that name as you want. You don't have to get it, trademarked publicly if you don't want to, okay? So also keep that in mind. And then when it comes to naming your trust, you do not have to have the word trust in the name of your trust. It doesn't have to end in the word trust, okay? It doesn't have to be in the name after. So once you're done naming your trust, then you are going to appoint your grantor, okay? So if you're creating an irrevocable trust, you want to be the trustee, so you're going to appoint someone to be your grantor on paper. And that individual needs to be able to have your trust notarized. So they need to notarize the trust with you. And once your trust is notarized, then they pretty much walk away from the trust. So you're going to appoint your grantor. You're obviously going to appoint yourself as the trustee because you want control of the trust, of the assets, of the funds, of anything dealing with that estate. Then you're going to appoint your beneficiaries. So your beneficiaries are your children, your next of kin, right? Whoever's, in your family. And with that being said, if you are operating a business trust, then you would want the beneficiary of your business trust to be your family trust. That is the best way to structure that type of entity. And then you're going to choose your successors, right? Because it's important. Tomorrow is not promised. So you need to have a successor as soon as possible, because in the event that you become incapacitated, your trust needs to be continued to operate. So number 3 is we're going to be creating the actual trust agreement. So that's us putting our provisions in place, putting our restrictions in place, putting, all of our trustee powers, everything within our contract. Once our contract is completed, then we're going to get it notarized. You can go anywhere to get your trust notarized, and the individuals that are to get the instrument notarized is the grantor and the trustees. So you can have an unlimited amount of grantors, and you can have an unlimited amount of trustees. There's no cap on how many trustees you can have. So if you want 15 trustees, you can, and all those individuals will have the same power, okay? So once your trust is notarized, then it becomes legal. It is now a legal, living, breathing entity, and you can operate it at that point in time, okay? So hold on one second. So you can operate it at that time. So now when you, now that it's legal, you want to start operating it. So the first thing that you're going to do is open up a bank account, because when you're creating the trust needs to have value. There needs to be an exchange with that creation. Okay. So your trust has what we call a corpus. A corpus sounds exactly like how it sounds. A corpse. A corpse is a body. The trust has a body. The body is the actual contract or governing instrument. You need to give that body value when you're creating that trust. That value could be whatever you want it to be. Anything that has intrinsic value. Okay, so it could be precious metal, it could be land, real estate, vehicles, cash money, whatever it is. So usually I tell my clients, just put a $1 bill, right? That $1 bill that I showed you guys at the beginning of the call, right? That is going to be your initiation of the corpus, because you have to give it value. So the first thing that you're going to do is open up a bank account, right? And with this bank account, you are going to have a board meeting in order to document that you as the trustee are going to be the authorized signer for this bank account. You are opening up a checking account, savings account with Wells Fargo Bank, and you're the person who is going to have the debit card and the login credentials for the online portal, okay? So all of that is going to be documented in your board meeting. Your board meeting is the life of the trust, the blood bones of the trust, right? Everything goes down in the meetings, okay? And it's very important that you operate your trust the right way. So you're going to now have that meeting, and once you determine what bank you're going to go to, then you can take that board meeting with you. You can take what we call your certificate of trust with you, which is just a summary of your trust with your trustee powers, right? Because you have a private contract and you took an oath of privacy not to display this contract or to give this contract to anyone, okay? So that means that if you go to the bank and they ask you for a copy of your trust, you're going to kindly decline and say, no, my trust is private and you're violating my privacy rights. So here is the certificate of trust proving the identification or existence of the trust, okay? So that's what you're going to do. You're going to operate or bind your trust into contracts with that certificate of trust, okay? So now, once you've created this trust bank account, then you're going to do that initial deposit, right? So let's just say it's $1, or let's just say it's $1,000, right? You have to understand that that $1,000 actually came from you. It came from your personal your personal money. So what you're going to do is you're going to have the trust pay you back, right? Because you don't want to, you can actually issue the trust loans, and the trust can issue you loans as well, or they can borrow from you, you can borrow from them, okay? So you want to be able to get those funds back, right? So you are initially putting $1,000 into the trust so that the trust has that initial working capital, but at the end of the day, you need to be paid back. So you're going to do a promissory note from the trust to you, promising to pay you back $1,000 plus interest, let's just say 10% interest for 12 months, okay? And so then the trust is going to have that responsibility of needing to pay you back, okay? So that's what you're going to do when it's time for you to open up a bank account. Then after that is you are going to transfer your assets, right? So you want to transfer your assets as soon as possible, like yesterday, because anything can happen. And you having property in your personal name is a liability. I'm going to explain this a little further down into the presentation. But you have to understand that we are so consumed with being the owners of our house, right? And we're very proud of that. And I understand that. But a lot of us are not aware that it is a part of the public records, which means that if you have a house in whatever county, anyone in that county or anyone in the world, because I can go look up your county. I'm in Florida, you're in, North Carolina, I can look it up online. So anyone can go to the county website, can do a property search, and they can search your first and last name, and every single property that you own in that county will show up, or vice versa. They can put the address, and then your name and your contact information will show up. So you are on the public records, which means that you are low-hanging fruit for any lawyer or, anybody who wants to do something malicious like sue you, okay? So that's why you need to remove yourself as the owner. That's only one of the reasons. Other reasons are, transfer of wealth, which we'll get into. So now let's talk about how do you transfer your assets into the trust? Let's just say that you have a house, right? This house is in your personal name. When you purchased it, you got a warranty deed, meaning that no one is going to come and make claims against the title of your property, right? You have that title insurance. So what you need to do is, now that you have this trust set up, you want to transfer the ownership from your personal name to the trust. So you're going to do a quick claim deed. A quick claim deed meaning that there's going to be no claims against the title from the time that you own that property until the time that you are gifting it to the trust. So when you are filling out this quick claim deed, you are going to be the grantor on this instrument. So you're the person who owns it. And if it's like, a couple, a husband and wife, then you're going to put both names on there. And then the grantee is going to be the trust. So you're going to put the trust and the trust contact name on it. And then you're going to document it as a gift. So you'll either put $0 or $1. A lot of people are confused and they think that they have to sell their house to the trust, right? But then that's going to trigger what we call a taxable event where you have to pay taxes on that sale. You don't want to do that. You want to gift your property to your trust, which is what you're able to do, right? As long as your trust says that your trust can receive gifts, then you can gift that property to your trust, okay? So with that being said, after you have completed the quick claim deed, you are going to sign as the grantor, and you're going to sign in front of a notary. The notary is going to notarize it. Then you are going to go down to either your clerk of courts or your county recorder's office, and you're going to submit that quick claim deed. They are going to process it, and now they're going to be able to update the information to reflect that the trust is the new owner of the property. So now once that trust becomes the owner of that property, the trust is now responsible has all the financial responsibilities, meaning that the trust is now going to pay the mortgage. The trust is now going to pay the utility bills associated with that property. The trust is now going to pay the property taxes associated with that property, and, and do reserves for depreciation and maintenance. Okay. So it's up to the trust now. And that's with every single asset that you put inside the trust, not only a house, right? So for example, if you put your vehicle into the trust, then the trust is now going to be paying paying the insurance for that vehicle, paying for the maintenance and tires and gasoline and all that stuff. Okay. So it's the trust responsibility that whatever assets it possesses, that it comes from the trust estate. And you want to make sure that it's done this way, because if the trust owns the house, but the mortgage payments are coming from you personally, you're not operating the right way. You commingling funds, and it's looking like, it's looking like, I don't know the right word I want to use, but it's not looking right? Because the payments have to come from the owner, not from a third party, right? So you have to make sure that whatever the trust owns is coming from the trust account. So let's just say that you put your primary residence into the house, into the trust. Then what you want to do is you want to pay the trust rent, right? So let's just say your mortgage is $3,000, then you're going to pay the trust $3,000 in rent, and then the trust is now able to pay that mortgage $3,000. So it's a simple process, but you have to understand you want to operate the right way. You want to be a legal, lawful trustee. So there's a paper trail involved, and you need to be doing things the right way. So we're going to number 7, which is operating the trust, right? So operating the trust is you actually making sure that you are, controlling the assets, making sure that you're growing the trust fund, making sure that you're buying, you're selling, you're doing whatever you need to do in order to maximize the trust estate. Okay. So that's what operating the trust is. So you're doing board meetings, right? So with these board meetings, you can determine how many board meetings you want. So if you want to just do one board meeting per year, you can do that. And in that board meeting, you're going to document everything that's occurring, right? So you're going to have the trust name, you're going to have all the parties that attended, right? So those could be officers of your board if you decide to elect officers, and those can be beneficiaries, right? Beneficiaries can come and attend, and trustees and co-trustees, okay? And so with this board meeting, you're going to notify them at least 2 weeks before the meeting occurs. And in the meeting, you're going to be talking about the financial status of the trust and what the future projections are for the following year. That's primarily what the meeting is. And if you want to be transparent, then you'll be able to show like financial statements and things like that. Okay. So the board meeting minutes are required, and you definitely want to do it. You want to do it for things that are important too. So not only having an annual meeting, but also having meetings for things that are major, like you opening up a bank account is major. You buying a property is major. You selling a property is major. So you want to be able to document all of that in your meetings, and then you're just going to add it to your trust. So what do I mean by add it to your trust? When you're operating your trust, you're going to have a binder, and this binder is going to be subdivided into several sections. So the first section is going to have your actual indenture or your contract, okay? So because you need to be able to reference your contract at any point in time, you don't want it to be, in a safe collecting dust, right? So you want to be organized. So you're going to have that as the first section. The second section is going to have any of your schedules, your schedule A, B, C, D, right? And so that's just going to show the assets that are in the trust, as well as any type of like titles or any type of deeds or anything like that, or like your insurance policy, anything like that, proving the assets, right? Any stock certificates, whatever. Then you're going to have your board meetings, right? So all of your board meetings, you're going to have it in that binder as well. And then you're going to have any contracts that you bind the trust into. So for example, if you go to the bank and you get a line of credit, then you want to be able to have that, that documented that you have a line of credit, you know, under the trust, and any type of promissory notes. And then the last section is going to be any financial responsibilities. So those are the utility bills, the car notes, the mortgage payments, all that stuff. So that's how you want to be operating your trust. And once you have it all organized and you have, you know, you're choosing a successor, you're able to go through all those things with your successor so that they familiarize themselves, so that once the time comes for them to take over, you're just handing over your binder. Okay. So let's talk about asset protection, right? The number one reason why you want to create a trust is for asset protection. That is the number one reason. And obviously to have that privacy component as well, right? But asset protection is the number one reason, because you don't want creditors coming after you, and you don't want, you know, you don't want to be sued. You don't want people to garnish your wages. You don't want people to know what your net worth is. There's so many reasons. Okay. So with that being said, a trust can actually protect you from bankruptcy, from heavy taxation, from divorce, from probate, from lawsuits, from foreclosures. Okay, so let's just talk about it. If you are off of mute, can you please mute yourself? So let's talk about it, right? Let's talk about lawsuits. So with lawsuits, let's just say that you have a property, right? And it's a rental property, and you have, you know, you have, hold on. Thank you. So let's just say that you have a property, right? So you have a rental property and you have tenants in that rental property. They slip and fall, guess what? They're going to sue you. So what you can do is you can protect yourself by obviously having that rental property be owned by the trust, because now at that point in time, they have to sue the trust and not you. So sometimes they can't even come to the point where they're able to serve you, because the property is owned by, let's just say, 123 Trust. And if it's owned by 123 Trust, they don't know who to serve, right? Because you are operating with full privacy. So you don't have to disclose that you're the trustee. You don't have to disclose who the beneficiaries are. So that puts you in a position of power and protection, right? Let's just say that you have a company, right? Let's just say that you have a business. That business is owned by you, right? So right now on the Secretary of State, anybody can look up that business, and all they have to do is put the business name, and your name pops up as the owner of that business. So if they wanted to sue that business, then they're able to come after you personally, right? Because they're suing the business, and if this business ends up in litigation, the judge can pierce the corporate veil, because you are running what we call a limited liability company. And so a lot of people don't understand that limited liability it really stands for limited liability, meaning that you don't have full liability. You don't have no liability, right? So you are not protected, right? So because you're the owner of that LLC and the judge decides to pierce the corporate veil, then they're going to come after you personally for that business, right? So that means that they can seize your assets, they can garnish your wages, they can freeze your bank accounts. So you don't want it to get to that point to where they're doing that, right? So you need to protect yourself. And so a trust can actually do that, right? So the way that you protect yourself in that situation is by removing yourself as the owner of that LLC. And then you're going to do an amendment for your articles of incorporation, you're going to remove yourself as, you know, the authorized member, and you're going to add your trust as the new authorized member of that LLC. So now at that point in time, the trust is the owner of the business, and they are going to take full liability. So you as the trustee, let's just say that the trust is sued. You as the trustee, you have no liability, meaning that they can't come after you personally for anything that you own in your personal name, which is great. And the same thing is vice versa, right? So if you are sued personally, they can't come after your trust, right? If all of your assets are in your trust and you're sued personally and you have no assets, you're also protected, right? Because you are pretty much broke on paper. And so they can't come after you, or they can't come after your trust, right? So that is, and the same thing applies with the beneficiaries as well. If the beneficiaries are sued personally, they can't come after the trust. Or if the trust is sued, they can't come after the beneficiaries. So that is a good thing. The next thing I want to talk about is probate, right? So probate is something that is inevitable, right? We're all going to go through probate. And that is only if we don't have our affairs in order. So you need to have your affairs in order if you want to avoid probate. And the only thing that can avoid probate is a trust, okay? So let's talk about probate. So a lot of us, the number one question that I want to ask you guys, right? And I always ask this question and I love it. So if you have a house right now, and this house is in your personal name, and you have 2-3 kids, how do you think that that house is going to transfer from your personal name to your children's name? We do not think about that. We don't think about the transfer of wealth. We're always just thinking about acquiring the wealth, right? Let me get the house. Let me get the car. Let me get the big bank account. But we don't think how it, like if I die tomorrow, how is this property going to go to my children? So if you don't have your affairs in order, then guess what? If you pass away, your estate is going to issue you an estate. And that estate is going to go to probate. So all of your assets, your properties, cars, bank accounts, is going to go inside of that estate. That estate is going to be represented by a lawyer, right? By a probate attorney. And you're going to end up in probate court. And anything that you had as an individual, meaning any debt that you had, if you had student loans, if you had, credit card debt, all of that stuff is going to be taken out of the estate as well. So what is the process, right? So once you're going through the probate process, first, all of your creditors are going to be paid. Then the attorneys are going to be paid. The court is going to be paid. And the judge is going to determine that, that the property is going to be transferred to the children. And at that point in time, the children, they get whatever's left over, right? Whatever's left over from after all of these parties get paid. So if you want your children to go through that process, you are doing them a major disservice, because you have to understand what's happening, right? They just went through a major loss, right? They just lost their parent. They're grieving, they're emotional. Maybe now they're, not seeing eye to eye. So probate can actually go on for years. We've seen it in the public, right? Especially with, famous people. And you are going to be doing your children a disservice if you're making them go through that process of probate. So the only way for you to avoid probate is by having a trust estate, because your trust is not going to end up in probate unless you have an alter ego trust, which is a living trust, right? Which you are the grantor, the trustee, and the beneficiary. That type of trust is not going to hold up in court. But if you have a solid trust, a bulletproof trust, then you will be able to avoid that entire process for your loved ones. So I know that you're creating generational wealth, but you also have to protect that generational wealth. And you also have to think about the transfer of that generational wealth. Another thing that I like to talk about is heavy taxation, because we are giving away half of our money to the government. And that sucks, right? Because you want to build wealth, but you're giving half of it away to the IRS, to the state, to all these different people. So with a trust, you can actually avoid heavy taxation, right? So for example, with probate, if you're off of mute, can you please mute? Can you please mute yourself? So with heavy taxation, for example, you have what they call death tax, right? So a lot of people, they don't know that the government or the IRS taxes them when they die. You are a human resource to the government. So when you die, they need to get paid. So they're going to tax you. They're going to tax they're going to tax your kids in inheritance tax. They're going to tax your estate in estate tax, right? So all of that happens through like the probate process, right? So keep that in mind. So with a trust, you can actually avoid all of that. So you can avoid inheritance tax, death tax, estate tax, and it depends on the type of trust that you're also operating too. Because if you have what we call a tax exempt trust, so if you have what we call a tax exempt trust, then that type of trust, other names for it is faith-based organization, ministry trust, church, things like that. That trust is exempt from federal taxes, state taxes, property taxes, sales taxes. So if you are operating that type of trust, you're saving a lot of money. So when it comes to trust, you can actually determine what is considered taxable income, right? So that's powerful. You as the trustee, let's just say that $100,000 went into your business trust or your family trust. You as the trustee can determine what is considered distributable net income, right? So 100,000 in revenue came in, and if you deem that that money is not taxable income, then guess what? It's not taxable income. They can't tell you nothing, because it's in your governing instrument. And with this type of entity, you are governing yourself, right? You're not under state legislation and dealing with their rules and regulations. So that is extremely powerful. Another thing is, with that type of entity, let's just say you're a W-2 employee, right? What you can do is you can donate 60% of your gross income to your trust. And once you do that, then you're only going to be taxed on 40% of your income instead of 100. So that means that you're going to be saving a lot of money on taxes. And what are you going to be doing with that extra money that you're saving? You're going to be investing it. You're going to be growing your wealth faster than you would have if you had to pay the IRS $10,000. So that is extremely powerful. And that's why in the beginning of this call, I said that a lot of these billion-dollar organizations, they pay close to zero taxes because of using this type of structure. So you have to do the same thing. So let's talk about the wealth building formula, because it's very powerful, right? I know that we're in this phase where we're building generational wealth and we're so focused on the money. So we need to understand how to be structured the right way in order for us to be maximizing and actually growing that money, right? Because we can make $1 million tomorrow, but are we going to keep the $1 million? Are we going to protect the $1 million? Are we going to preserve the $1 million? So let's talk about structure. So you have 3 different trusts here that you want to definitely incorporate in your structure. So the first one is a business trust, okay? A business trust is exactly how it sounds. It's for you to conduct business. So this business trust, you can actually operate your entire business through this trust, or you can have this trust be the owner of another business, right? So this trust can actually act as a holding company, and then it can own your LLCs or your S corporations or any other type of holding company that you might have in your structure, right? So that's extremely powerful. So now let's just say that you have an LLC, right? And you already did the amendments and the business trust is now the owner of your LLC. When you're filing your taxes and you know that with your LLC, you're filing it in conjunction with your 1040, right? So a LLC is a pass-through entity, right? So that means that you're going to do a K-1 distribution and you're going to distribute 100% of that money. So let's just say $100,000 came in. $100,000 is now going to be transferred from your LLC into your business trust. And at that point in time, you can do a few things. So the first thing that you can do is you can leave the money inside of the business trust. And if the money stays inside of the trust, then it doesn't trigger a taxable event, which is powerful, meaning that you don't have to pay taxes if you're not, doing any type of distributions and things like that, right? So that is powerful. Another thing is, like I told you guys earlier, you as a trustee can determine what is, taxable income and what is not. So if you deem it not to be taxable income, then guess what? The government can't tell you nothing, right? It's not taxable income. So that's another thing. And if you need to use any funds, right, from the business trust, right? If you decide I'm going to keep the $100,000 in the business trust so I don't trigger a taxable event, but you need to use funds, then what you're going to do is you are going to take out a loan from your trust to be able to use those funds. So instead of doing it another way, which is you 1099ing yourself and having to pay taxes on that 1099 income, right? That's not the way you want to do it. The alternative is for you to have the trust issue you a loan, right? So that trust is going to issue you a loan for $50,000, and then you're able to use that money personally on whatever personal expenses that you have that's outside of the trust, and you don't pay taxes on loans. So that's how you're able to pull money outside of your trust without having to pay taxes. That's extremely powerful, okay? So don't let that, pass you by. So another thing is that with a trust can actually transfer, a certain percentage or all of its money, however you want to do it. They can transfer the money to their beneficiaries, and then they won't have to pay taxes on that either. So if you had the $100,000 in your business trust, then you can do a distribution to your private family trust. And then at that point in time, your tax liability for your business trust will be zero. So now all that money is in your private family trust, and then you're going to do you're going to expend it all, right? So if you expend the $100,000 down to zero, you pay zero on zero, right? If you spend it all. So that's one of the lovely things of this entity, right? Is that you get to spend the money first and pay taxes on what's left over. So if you have nothing that's left over, or if you in the negative, then guess what? Like, you have no tax liability. So that's extremely powerful as well. So you want to expend as much as you need to, or as you want to. So Business trust, you're going to be expending business expenses, right? Whatever you need in order to operate, any type of administrative stuff. With your private family trust, you're going to be expending on your family, right? So with your private family trust, that is the entity that you are going to use as your asset holding trust. So that means that all of your assets, your primary residence, your cars, your insurance, cash, all of those assets are going to be held by your private family trust, right? And that trust is private. So you're not going to be building credit with this trust. You're not going to be just having the name all exposed out there like as you would with the business trust. That's why you want to have multiple trusts within your structure. It's extremely powerful because one trust, you want it strictly private and for assets only. And then the other trust, you want it to be out there in the public. You are dealing in commerce, you're dealing with clients and customers and all that stuff. And that trust obviously is, liable of getting sued. So you don't want to have no assets in your business trust. Okay, no assets. So so with that being said, if you are, if you have business revenue in there, you only want to keep a minimum of whatever it needs in order to operate those businesses, okay? Because in the event of a lawsuit, right, you always have to think about this. Because like the United States is a sue-friendly country and you don't want to be caught slipping. So you need to be able to protect yourself before the lawsuits even come. So that's why you don't want to have any assets with the business trust. You want to have all of your assets with the private family trust, okay? And so that's where your mortgage is going to be taken out, the kids' tuition, the groceries, the car note, the gasoline, all of the things that you need in order to sustain your lifestyle and your children's lifestyle is going to be taken out of the private family trust. So you're going to expend almost everything, whatever's left over. So let's just say out of that 100,000, you expended 90,000 and there's only 10,000 left over. What are you going to do with that 10,000? Are you going to pay the government? Are you going to pay taxes? Because you're going to be required to pay taxes, because with a private family trust, it's at a high tax bracket. So it's taxed at 38%, right? And they do that strategically because they don't want people out here really operating trust, right? So you're going to have to pay 38% on that 10,000. Or an alternative of what you can do is you can donate it, right? You can donate that 10,000 and then guess what? Your tax liability is zero. So with that 10,000, you're going to donate it to your faith-based organization or ministry trust, or another name that we go by is a 508c1a designated trust. Okay, so with that trust, that is a tax-exempt trust. So meaning that it doesn't have to file for a 501c3. So it's a nonprofit, right? So within your structure, you want to have a for-profit arm and a nonprofit arm. That is extremely important because there's a lot of benefits to this, okay? So you have a nonprofit, that's your tax-exempt organization. That is your 508c1a. It's a designated trust. That is the only exception to not having to file for a 501c3. Is a 508c1a designated trust, okay? And the reason why is because that is the separation between church and state, okay? So they had to put that in there in order for it to be that true separation, right? So churches, you don't really have to apply for a 501c3 because you're already automatically exempt if you are a church or a ministry or a faith-based organization, or if you're doing anything relating to charities, religious, practices, educational programs, things like that, okay? So that type of trust is extremely powerful. So what are you exempt from? You're exempt from filing federal taxes, right? So that means that you don't have to file taxes, and you don't have to report your board meetings. You don't have to apply for tax exempt status, and you don't have to report any of your financials or your bookkeepings or anything like that, which is really good, right? So you're exempt from federal taxes. You're exempt from property taxes, right? So think about a church. A church has a physical building or land, right? So with this type of trust, you can only qualify for property tax exemption for one property. Okay. So if you were using this within your real estate strategy, then you would have to get multiple 508c1as if you wanted all of your properties to be exempt from paying property taxes. Okay. So that's extremely powerful. You are exempt from sales taxes, but you have to apply, and state taxes, depending on your state. Okay. So like I said, you can donate whatever is left over. You can donate it to yourself, to your nonprofit trust. And then once it's in your nonprofit trust, the filing taxes is over, right? You don't have to file anymore. And once it's in the ministry trust or the faith-based organization, you can do whatever you need to do. So you obviously want to operate that trust the right way, right? So it's for charitable, philanthropic things. So you want to have all those things in place. So you donate to your charities, right? But what you can do with the rest of the money is you can invest, right? You can invest in the stock market. You can invest in other businesses and become a shareholder of those businesses. You can invest in real estate, right? So there's no restrictions on you being able to also build wealth with that type of structure. And let's just say that you got like $1 million in property or revenue or something like that, right? Then what you would do is, because it's a nonprofit, you can't just, you can't commingle funds, right? You cannot not operate it the right way. So if you personally wanted to tap into that $1 million, then you would have to render a service to that ministry trust and pull out the money that way. So you would have to 1099 yourself in order to pull money out of that nonprofit, or you can sell those assets, right? You can sell them to, to your other trust, right? So think about that, when you are building wealth, how powerful that is. Okay. So now the next pillar is credit. Like I told you, your trust can build credit just like you as an individual can, just like your LLCs and those other state entities can. So you want to be able to tap into building corporate credit for your trust. So it's the same way, right? You are going to, you're going to establish a DUNS number, and then you're going to build up, your net 30 accounts, and you're going to generate a paydex score. And if you want to tap into line of credits and credit cards, you will, most likely have to be a personal guarantor to be able to get those lines of credit. But just know that your trust can get lines of credit and can get loans, just like a business can, okay? So you want to keep that in mind, because now what you want to do is you want to put your trust in position to where the estate is creating passive income, right? You don't want to be using your W-2 money and pouring into the trust and pouring into the trust. You want the trust to be able to sustain itself. And so the way that's going to be done is by you generating passive income for the trust. And so the way that you can do that is by tapping into corporate credit, tapping into nonprofit grants, things like that, and using those funds to invest, okay? So for example, the next pillar is investing, okay? So now we're gonna tap into investments. These investments are super powerful because you wanna put yourself in a position to where, like I said, the trust is generating its own income, right? It has nothing to do with you. So one of the investments that I highly recommend, right, especially during these times, because right now We're in questionable times. You got the Fed now, you got, you know, the digital currency, paper money is going to be going away, all this stuff, right? We really don't know where the economy is going. So you need to protect your money. And how are you going to do that is by having an asset that has full liquidity, okay? So what asset has full liquidity? Not real estate. Real estate doesn't. Let's be honest. You have to put the house on the market. And at this rate, in my neighborhood, houses are sitting on the market for 8 months plus. Okay. So the real estate market is even questionable. So you want to be able to utilize your insurance policy, right? I don't know if you guys have heard of these terms, but let's just talk about it. Infinite banking, private money banking, be your own bank. That is exactly what you need to do. That's what you need to do. You need to be your own bank, especially during these times. So how do you do that? You do that by actually having the trust take out an insurance policy on you, okay? So you have to understand that you are the trustee or you are the beneficiary, right? So you are a human asset in your trust. Your trust has physical, tangible assets, right? Your trust has real estate, your trust has cash money, but your trust also has humans involved, natural persons. And those humans are resources, are human assets. So if you die, guess what? The trust needs to be compensated for that loss. So what the trust is going to do is it's going to take out an insurance policy on you. So you are going to be the insured. The trust is going to be the owner of your insurance policy and the beneficiary of your insurance policy. Okay. So that's extremely important that you have it structured that way. So with your insurance policy, you need to have the right one. Not all insurance policies are the same. So you might already have an insurance policy, but the specific policies that you need are policies that are building cash value. So if you have a whole life policy, that's building cash value, but it's building cash value at a slower rate. So you have what we call like a guarantee, and it's usually building at like 4%, right? 4% interest for the year. Another policy is an index universal life insurance policy. That's the policy that I have for me and my family. And that policy builds cash value, right? But it also has, you know, a death benefit attached to it. So it's tied to the index, right? You have different indices. You have the Dow Jones, the S&P 500, the NASDAQ. So you can actually choose whichever index that you want your policy to mirror. So me, I've chosen the S&P 500 just because I like the diversification of that specific index. So with that being said, since your policy is mirroring, let's just say the S&P 500, then that means that whatever the S&P 500 does, your insurance company is going to match it. So if the S&P 500 is doing 9% for the year, then your insurance policy is going to give you 9% compound interest on your cash value for that year. So that means that you're actually going to be making more money faster with an index universal life insurance policy versus a whole life. Okay, so that's extremely powerful because you want to be able to, you know, we want to build wealth fast, not slow. Okay, so you want to be able to earn more and to have it be risk-free. So let's just say that the market is down. Then the less that you can get is zero. So you can get anywhere between 0 to, I think it's upwards of 12%, right? So they'll cap you at that. So if the market is doing, 18%, you're only going to get 12. So that's extremely powerful, right? So you want to be able to use this insurance policy when you're living, not when you're dead. A lot of us, we get insurance so that our family could benefit when we're dead, but we need to actually be using these insurance policies when we're alive because they're considered assets. The insurance company looks at it as an asset, and other financial institutions as well. So if you look at these banks like Wells Fargo, Bank of America, and Chase Bank, their number one asset in their portfolio are insurance policies. So if that's their number one asset, don't you think that it should also be your number one asset as well? I think so. So now you need to, now that you are building up your own bank, right? You're being your own bank. You actually have to pay yourself first. So this is the way that you guys are operating now, right? So you are, let's just say, a W-2 employee. And once you get your paycheck, you already see that the IRS took their federal withholding, right? Tax. You already got contributed to Social Security, Medicare, right? So they already took all three of those. And you get what's left over, right? So that's what you get direct deposited into your bank account, whatever's left over. So then what do? We pay our bills, right? So that money goes into our bank account and we start paying our mortgage, our groceries, we put gasoline in our car, right? So we do all of our expenses. And then whatever's left over, we save. So if you just got $5,000 and $500 is left over, now you're going to save the $500. That is the wrong way of doing things. What you want to do is, and this takes a mindset shift. What you want to do is you want to pay yourself first. And the way that you're going to pay yourself first is once you get that $5,000 on Friday, instead of you paying all of your expenses and saving the leftovers, you are going to put that $5,000 into your insurance policy. So now that you made a payment to your insurance policy, it's building up your cash value. So now your cash value went up by $5,000. And like I said, this is a liquid asset, which means what? You can borrow from your asset. So you're going to contact the insurance company. You're going to do a disbursement. You're going to ask them for a loan and you're going to do a disbursement, right? You're going to ask them for a disbursement and they're going to direct deposit the money back into your bank account. So this is what happens. When you ask the insurance company for a loan, they look at your asset, which is your policy. They see that you have the $5,000 in cash value. So then they are going to issue you a disbursement of $5,000.
I don't know exactly where I put it. It should be.
Can you mute, please?
In the nightstand, it might be in the basket, in the closet, when we put the other stuff. I don't remember where we put it.
Mia Harris, you're unmuted.
I'm sorry.
Thank you. All right. So the insurance company looks at it as an asset, right? And they see that you have the $5,000 in your cash value. So what they're going to do is they're going to issue you a loan from their own money, from their reserves. So your $5,000 is going to stay inside of your insurance policy, working, generating 9%. And now the insurance company is going to direct deposit the $5,000 back into your bank account. And now since you paid yourself first, now when you get that money back from the insurance company, that loan, which you don't pay taxes on loans, you're able to pay all of your bills, right? You're able to now pay the mortgage, pay the utility bills, pay your car note. So that is the way that you want to do things. Pay yourself first. And I'm telling you, it's a mindset shift. But once you get started, it's going to be second nature to you. But you have to get into these financially responsible actions in order for you to truly build the wealth that you want to build, in order for you to truly have the generational wealth to where that it's lasting for 10 generations down the line. Because this is what you want to teach your kids. Be your own bank. Have the trust own multiple insurance companies and policies in order for you to have this infrastructure in place. So the trust is actually going to have a policy not only on you, but on everyone attached to the trust. So all of the beneficiaries and all of the future beneficiaries. Okay. So back to what we're talking about with the loan, right? You do not have to pay that loan back. So you got the loan for the $5,000. You do not have to pay that loan back. That loan is going to be taken out of your death benefit. So with an index universal life insurance, the reason why I love this policy so much is because you're building cash value. And if you're doing this strategy, then you're overfunding your policy, okay? Because you're dumping in all of your income into the policy, right? So you're overfunding it. So it's building cash value. And then it also has a death benefit. So once you expire, your trust is the beneficiary. So your trust is going to get that cash value and the death benefit. So both buckets, right? Both of those accounts are going to go, or funds are going to go to the trust, okay? Because the trust is the beneficiary. So that is extremely powerful. So you want to be able to have your trust own the policy. And this is also a strategy, because if you have your insurance policy in your personal name, then you're going to be subject to, not you, but your death benefit. Your death benefit is going to be subject to inheritance tax, death tax, estate tax. So if you don't want the IRS taking a piece of that death benefit, then you don't want your policy to be in your personal name. Okay. So if you have a policy already, then you're setting up a trust, then you want to be able to contact your insurance company to let them know that you're changing the owner and the beneficiary. But there's a 3-year rule with the IRS, meaning that if you die within 3 years of transferring the ownership of that policy from your personal name to the trust, then those taxes are still applicable. So they're still going to charge you an inheritance tax and an estate tax. But if you don't already have a policy, please do not get this policy in your personal name, meaning you don't be the owner, you don't take it out, you don't apply for the policy yourself. You have the trust apply for the policy, okay? That is extremely powerful, because now you're avoiding that 3-year rule, because you were never the original owner. The original owner was always the trust, okay? So keep that in mind. So now let's go back to credit, right? So you guys tapped in, you got a line of credit, for $50,000. What is the first thing that you're going to do? The first thing that you're going to do is you're going to pay yourself first. So you got a line of credit for $50,000. You get to take that money out, and now you're going to dump it into your insurance policy. So now your cash value went up by 50, and you're going to make 9%, 8%, 6%, whatever the market is doing at that time. You're going to make that money on the insurance, right? Through your policy. You're going to borrow out that $50,000. And then guess what you're going to do? You are going to invest that money in real estate, right? You also need tangible assets. You have liquid assets, and then you have tangible assets that are not so liquid, right? And so real estate is actually very, very, very powerful.
So this offer is for a balance transfer, or what they call APR, for check cash advances.
Can you mute?
They're using cash.
I think it's Michael.
They're using the word balance.
All right, there we go. So you're going to invest it in real estate, right? So real estate, I love real estate. I'm a real estate investor. And so what you want to do is you want to use that $50,000 as a down payment, right? You're going to use that $50,000 as a down payment for real estate. And so let me just quickly tell you about my strategy when it comes to real estate. And you can, whatever strategy you're using at this time, right? So traditional real estate investors, what do? They buy a house. Let's just say that this house is like a 4-bedroom, 2-bath house, and they're going to put a family in that house, right? And then they're going to receive 12 months payments, right? For the year, right? So 12 payments for the year. But you have to do the math, right? So with that being said, there are 52 weeks in a year. If you divide 52 by 4, what number do you receive? 13. So that means that there's actually 13 months in a year. But you, as a traditional real estate investor, are only collecting 12 of those 13 months. So how do you recover that extra month? The way you recover that extra month is by charging weekly versus monthly. So now instead of receiving 12 payments, you're going to receive 52 payments for the year. So that means that you are making more money. Powerful. So another strategy that you can use is, instead of you with this 4-bedroom, 2-bath house that we are using, instead of you renting it to one family, you can rent it to 4 different tenants. You got 4 bedrooms, right? So you're going to rent it to professionals that are like traveling nurses, like once upon a time myself, right? So I do this strategy, and I know this strategy because I was in that position. I was a traveling nurse for, I think, 6 years. And I used to rent rooms, right? And it's extremely powerful. It's kind of like Airbnb, but not so invasive, right? So you're going to rent it out to professionals that are needing a place to stay. They're in between houses, or they're there locally for 3 months, stuff like that, right? And you're going to rent it on a weekly basis, and you're going to have that sweet spot of a price, which is $300-400, right? It's not $1,000 like a hotel, and it's not $700 like a Airbnb. $300-400, right? So now you're actually making more money. So if you do the math on a monthly basis, your revenue is going to be $5,000 versus $2,500 that you would get from a traditional family. So you have to think about that, right? So now with that $5,000 that's coming in monthly revenue or weekly, right? What are you going to do? You are going to park that money into your insurance policy. So whatever comes in on a weekly basis from your rental property, that money is going to go into your insurance policy, and then you're going to borrow it out, and you're going to pay the mortgage on that rental property. So now you have 2 passive income streams for your trust. So now your trust is generating its own income. And that was possible because you decided to tap in to corporate credit for the trust and put the trust in position to make its own money, to generate its own wealth for your heirs. So that's the position that you need to put yourself in. It's extremely powerful, and it's really important, okay? So how do you transfer wealth? We're about to wrap it up, guys. So how do you transfer wealth, right? Like I said, we are creating generational wealth, and we're focused on the money, but we don't focus on how is this money going to be transferred? If I don't wake up tomorrow, how are my kids going to get this money? So you want to put yourself in a position to where you own nothing but control everything. That is one of the most powerful statements that I've ever heard. And it's time for you to adopt that statement or that mantra into your life. Own nothing but control everything. So we're not going to be proud that we own this house. We are going to be proud that we control this house, that we control the bank account under the trust name, that we control the insurance policy for the trust. That's what we're going to be proud of. So that's what we call stewardship. So it's either ownership or stewardship. Which team are you on? Stewardship, right? Stewardship is you being a good steward of your wealth, meaning that you're taking care of your wealth. You're guiding your wealth down the right direction. You're going through a journey with this wealth. You're actually controlling the wealth. And you are developing distribution systems, administrative systems in order for this wealth to be transferred, right? So, stewardship versus ownership. Now, how is this wealth transferred? So, the properties that you have in the trust, right? So, normally, these properties are in your personal name. And if you expire, then that means that your kids have to go to probate. That means that there actually has to be a transfer. There's no other way for that house or that car or that bank account for that that's owned in your personal name to be transferred to your kids. There's no other way than the legal route. So if you want to drag your kids through that, by all means. But if not, then what you want to do is you want to obviously have everything owned by the trust. So now if you expire tomorrow and the trust owns the house, the car, the policies, the bank accounts, what transfer needs to take place? There is no transfer that needs to take place because the trust owns everything already. And you as the trustee, you expired, but guess what? Somebody's going to take over the next day. There's not going to be no litigation. There's not going to be no fighting. There's not going to be any transfer of ownership or anything. It's smooth. Why? Because you had your affairs in order. Okay, so that is what that's what the transfer is. So now let's talk about how it looks, right? So within trust, we have what we call UBIs, which stands for units of beneficial interest. The other name for it is trust certificate units. So these are TCUs or UBIs. Trust certificate units are just like stock certificates, okay? So you know how stock certificates, how you have ownership in like Apple or Google. It's the same thing. So with a trust certificate unit, you have, and we don't use the term ownership because a trust is a living entity. So it's just like you. It's living, it's breathing, it can't be owned. Just like you, you're living, you breathing, you can't be owned. So we don't use that terminology. We use beneficial interest. So meaning that the trust certificate units are representing the beneficial interest in the trust. So your trust is going to issue 100 trust certificate units to holders, right? To beneficiaries. And those units are going to represent their beneficial interest. So if you have, let's just say that you have 4 beneficiaries and you want them to, all 4 of them to have equal beneficial interest, then you're going to distribute 25 TCUs to each beneficiary. So now let's just say that you were going to do a distribution of $100,000 to the beneficiaries. Then you would issue the money in relation to their how many TCUs they hold. So out of that $100,000, the beneficiaries that have 25 units are going to get equivalent to $25,000. So I hope that makes sense. So that is what represents that transfer of ownership. So now when the trust is terminated or expires, the trustee is going to deed over any property, assets, money to the beneficiaries. And it's going to be in comparison to how many trust certificate units they own. So for example, in 100 years, when the trust expires and you have 100 houses and you have 2 beneficiaries and each beneficiary has 50 units, then that means that each beneficiary is going to receive 50 houses. So that is what the true transfer of wealth looks like. But the goal is for you to keep that trust going as long as possible. And that's where we get into preservation. So you want to preserve your wealth as long as you can. You want it to last generations and generations and generations. So the way that you do that is obviously by continuing the trust for as long as possible, right? So don't terminate the trust. Make sure that it's renewed. Okay, so that's one thing. The second thing is by having the insurance, right? So like I said, you are a human resource to the trust. So the trust is going to take out a policy on you, but it's also going to take out a policy on every single beneficiary. So whenever a new beneficiary is born, the trust is going to take out a policy on that individual. Okay, so that is how that generational wealth really happens, right? So that's extremely powerful, right? So it's going to be you and the co-trustees are insured, the beneficiaries are insured. Once there's new beneficiaries that are born, they're also going to be insured too, okay? So now it goes back to if and when you expire, right? The trust is replenished by that loss. So if you die tomorrow and your death benefit was $2 million plus some cash value, then the trustee at that time is going to provide the death certificate, and those funds are going to go straight to the trust fund bank account. So that is how you're able to preserve the wealth, right? With the loss of a human resource, okay? So another thing is, let's just say that the beneficiaries, I like to give this example. The beneficiaries, let's just say that they're 21 years old, they want to buy a new car, right? And normally the process is they're going to go down to a dealership. They're going to apply for a loan with the dealership, $30,000. The dealership's going to give them monthly payments for 5 years, charging them 10, 15%, right? Or more. So that's the normal process. But we have wealth here, right? We have a whole family dynamic here. And so what the beneficiary is going to do as an alternative is they're going to go to the trust or the trustee, and they are going to take out a loan for the money that they need in order to purchase that vehicle. So they're going to take out a loan for the $30,000. So the trustee, instead of taking those funds from the trust bank account, the trustee is going to go to that beneficiary's life insurance policy and borrow the $30,000 from their cash value and issue a check to the beneficiary for the $30,000, and obviously have a promissory note that the beneficiary is going to pay back the trust $30,000 plus interest in a 5-year term. So now, instead of that beneficiary paying the dealership $500, right, a month, they're now going to pay the trust, and it's going to obviously be lower interest, right? So now they're going to pay the trust $350 per month. They're paying back towards that loan. And so then that funds is going to go to the insurance policy, building up the cash value. But let's just say that beneficiary decides that they want to default on the loan. Guess what happened? Guess what happens? Because they decided to default on the loan and the loan came from their insurance policy, the loan necessarily doesn't have to be paid back. So that means that that loan eventually is going to be forgiven by the trust once the death benefit is paid into the policy, meaning once that beneficiary passes away, then the trust is going to receive that death benefit, and that is going to count as the forgiveness of that auto loan that they decided to default on. That is how the wealth is going to be preserved. But you have to have these provisions in place, and you have to be properly structured in order for you to be able to take advantage of this. So these are the books that I recommend, guys. So I recommend What Would the Rockefellers Do? And this is a really good book, and it's teaching you on trust, wealth creation, and utilizing your insurance policy to grow wealth. The Art of Passing the Buck, volume 1 and 2, and it teaches you how to operate as a trustee. Family Wealth, it teaches you on how to create a family office and a family business. And then the Complete Book of Trust, which teaches you guys the different types of trust so you could determine which one is the best one for you. So you want to take action on the information that I told you guys today. The trust is your new form of doing business and making profit. It can solve a lot of your problems and provide exceptional asset protection and tax savings if you decide to operate your trust the right way and implement that wealth building plan that I told you guys. So you want to treat this, you want to treat your trust like it's an Amazon, like it's an IBM. Can you mute? Let's see here. Perfect. Right? So you want to treat your trust like it's a business. That's the best way for you to do it. So you need to take action on the information. Don't just sit on this information and, and let it slip by, okay? Because it's super powerful. You need the right tools in order to build wealth effectively, okay? So let's work together. I do have a program that teaches you guys how to actually create the trust, right? So it's a do-it-yourself program. It has a total of 40 video modules. In these modules, you're going to learn what is a trust, the different parties involved, the different types of trust, and the benefits of it. You're also going to learn how to set up the 3 trusts that I was telling you about today. So that's the unincorporated business trust, that is the private family trust, and that is the faith-based organization tax-exempt nonprofit trust. So in the program, you're going to actually get video trainings on how to set up all 3 of those trusts. So you get the templates and you get the video trainings walking you through everything. So these trusts, and I'll show you a trust in just a moment. So these trusts are anywhere between 20 to 40, 50 pages, right? So in the video trainings, I teach you and I go through every single paragraph of the trust. And I teach you the contents of the trust, because how are you going to operate a trust if you don't know what's in the trust? So you have to learn what's inside of the trust, right? The governing instrument. And then you have to learn how to operate as a trustee. So you actually learn how to set up your trust. You learn how to apply for your EINs. You learn how to do your board meeting minutes, right? So we have templates on that. We have video trainings on that so that you can actually operate effectively and do your board meetings, right? Because a lot of us, we run in companies and we never did a meeting for our company, right? So you actually learn the right way. And then you also learn tax strategies. So a lot of the tax strategies that I was telling you guys today, you get the promissory notes and things like that. In order for you to be able to save on taxes, in order for you to be able to apply for like sales tax exemption and stuff like that, you learn all those things in the training as well, in the video modules. And then you learn how to transfer your assets, which is extremely important. I don't want to even tell you how many individuals I have talked to that they have had trust and for 2, 3, 4 years and have never used it, never used the trust. They're too afraid to use the trust because they don't know how to operate it, and they never transfer their assets. I was actually talking with an individual not too long ago, and her father, he had an irrevocable trust and he died, and she thought that the house was in the trust. And then she later found out that the house was never put inside the trust. And so she automatically has to go to probate. So she was devastated in tears about it. So you actually learn how to transfer all your assets in the program. So we provide you with the quick claim deeds, right, that you need in order to transfer your property. You learn how to transfer your vehicles, your insurance policies, how to amend your LLCs so that your trust is the owner of your LLCs, and what else? How to create brokerage accounts, bank accounts, things like that. And then we do the wealth creation part where you learn how to do the infinite banking and get your insurance policy. You learn the real estate strategy that I was sharing with you guys today, as well as stock strategies for investing in index funds dealing with the stock market so that you can generate more passive income with your trust. So that's everything that you learn in the program. We also have a Facebook group so that you can have that community component too, because it's important for you to also be building, relationships with other trustees that are going down the same journey as you. So the do-it-yourself, that is for people who are independent and they are able to, to really be able to efficiently get things done. That is $997. If you feel like you're an individual who needs help, you need some handholding, you need accountability, then you want to do the done with you. So that is where we work together one-on-one. You get a total of 5 Zoom calls where we're actually setting up all 3 of your trusts, applying for your EINs. We are doing your first board meeting together, and then we'll transfer any of your assets that you have together. So it's unlimited Q&A. You also get lifetime access to the course, right? So you get access to the Facebook community and the course, which is highly beneficial because let's just say like right now you do the course, you set up your 3 trusts, but then 2 years down the line, you want to set up another trust. You just log into the online portal and you're able to download those templates and stuff. And with the done with you, you get to set up your trust the right way. So that one is $14.97, and that's for individuals who need the accountability. They want to make sure that the trust is being set up the right way. Because something that I have seen is that people, they'll sign up for courses and then they'll never go through the course. They probably go through 10% of it. And so that's money that's wasted. So you need to be able to actually have that accountability and take action. So I'm going to show you guys the program and I'll show you a sample of the trust and then I'll take questions. So this is an example of what a trust document looks like, right? So everything that you see in red is what you're going to be filling out, like if you decide to go into the program, okay? So here we have a table of contents. We have your declaration and your indenture, which is your agreement. And I'll just continue to scroll down and you guys can see the stuff that is in red is the stuff that you want to customize. So these are all the provisions and sections in place that you need in order to protect yourself and your assets and actually establish your trust estate, okay? And then we're going to go down to the bottom where you're actually going to legalize your trust. So let's see, let's get down there. So you have your signature page here where the grantor is going to sign, right? So if you're creating an irrevocable trust, you're going to appoint somebody like a mother or like a parent, a sibling, a cousin, whoever, to be your grantor, someone who's able to actually notarize the document for you. But then just know that they don't have any power, right? They just walk away from the trust. And so then you are considered the first trustee or the founder trustee, and you're going to sign, you're going to get it notarized. And this is what makes your trust legal, okay? And then you have other sections in place, which is a Schedule A, which is the creation of your trust certificate units. You have the distribution of your trust certificate units. You have a Schedule B where you're going to be listing the properties. A Schedule C, which is the beneficiary contact information. A Schedule D is where once the trust is terminated, you want, for example, you want all of your houses in Mississippi to go to this child and all the bank accounts to go to that child. You can specifically name the property and who the beneficiary is going to receive, right? And then your certificate of trust, this is what you are going to take everywhere. So when you're opening up that bank account, when you're purchasing a car for the trust, when you're purchasing a property for the trust, whatever you are doing, you're going to use your certificate of trust in order to to prove that this type of entity actually exists, okay? And then this is the program. So this is the Wealthy Trustee program. Like I tell you, there's a total of 40 lessons, and I'm always adding more lessons to the program as well, okay? So in the first section, we have the trustee entity. So what is a trust? Who's the grantor, trustee, beneficiary, successors, protector, stuff like that. You get into actually going through the declaration, the articles, the bylaws for the 508c1a, for the private family trust, for the unincorporated business trust. Then we go through tax strategies. We go through asset protection. So you're actually going to do an inventory of your assets before you start transferring assets, okay? So you learn how to transfer all of these assets. And then we have the wealth creation, where I'm teaching you guys all of the strategies in order for you to build wealth. And then you have your resources and ebooks. So with the ebooks, I have, I think, 3 different ebooks, and these ebooks are super expensive. So like one of the ebooks is 600 pages and it's worth like $700 on Amazon, and you get it, you get it free in the program. So this is the program, and that's it, guys. I'm open for questions, comments, concerns. You can come off of mute if you have a question.
How long does it usually take to set all this up?
So it depends on you and your speed. So I have had clients do it in 24 hours. And I've had clients who just sit on it, don't get it notarized, and they take weeks.
Okay.
How do you get the, so I know after you create the trust, you go to the bank and then you get like a loan on your trust to dump into the insurance, right? So what would determine the amount of money that you can get if it's a new trust that hasn't built credit?
Yeah, so it depends on the financial institution. So whatever financial institution you have. So I have clients who, like one of my clients told me on Monday that they got approved for $10,000. I have another client got approved for $3,000. So it also depends on your credit worthiness, because you are the personal guarantor. If you have A1 credit, 750 or higher, then they're going to give you a higher line of credit because it's considered business credit, and usually business credit gets higher lines versus personal credit. So you actually do not have to have any established credit in order to get credit for your trust, because you are personally guaranteeing if you decide to do that.
So then your personal name, though, then is attached to the trust. So they basically run you at the same time that they would run the trust?
So it's not attached to the trust. And it also depends on the financial institution if they decide to report it to your credit. So some of them don't. Some of them don't report it to your credit. And sometimes it's just like an internal thing dealing with the bank. But yeah, you are actually, since you're personally guaranteeing it, that means that you are going to hold yourself liable. So that's why I said it depends on your goals and what you want to do. If you really want to get the line of credit and you know that you are going to flip the money into your insurance policy and into real estate, then you might want to take that risk. But if you decide, all right. So if you decide that you don't want to do that, then you don't have to. You can actually have the trust build its own credit, but that takes a while. It takes about like probably 2 years or so. It needs to be seasoned.
So then, like, full transparency, I just had a bankruptcy that is still not even fully through. So like myself, what would be the best way to go?
So with your bankruptcy, honestly, like I said, it depends on your credit worthiness. So I'm not sure like where you're at. So it's really hard for me to answer that question.
Okay, thank you.
Do you not consider the no-doc loans?
Oh yeah, you can. It depends on the financial institution. So like if you're going with Chase, if you're going with Wells Fargo, whoever, It depends on if they do no doc loans. Some of them do, some of them don't. But I've seen it to where they don't, to where they do no doc loans. Like one of the banks that I use is called it's called, what is the name of this bank? Oh, Jesus, I'm drawing a blank. I'm sorry, I've been talking for a while. It's called, I can't remember, but they do no doc loans up to $50,000. So like I said, it depends on the bank. Credit unions are definitely more generous than your traditional banks.
What's a no doc loan?
A no doc loan is where they don't ask you for proof of income. They just go based off of your like projected income. And so you don't have to give any tax returns or anything like that. No docs, no documentation required.
Wow, okay.
Yeah, so they go based off of your credit worthiness as well. I have a question from nine either. You have your hand up?
Thanks. Nine Ether, yeah.
Nice.
I'm at Jamaica Corporation. I own nothing. Can I do this from here? Is it possible?
I don't understand the question. Are you in Jamaica?
Can you do the trust and the index insurance from here?
Are you in Jamaica? Is that what it is?
Yeah, that's what I'm saying. Yeah.
Oh, okay. Because you said I have a Jamaica corporation, so I thought you just had a corporation in Jamaica.
No, I'm at Jamaica.
You're in Jamaica.
Yeah.
Okay. Honestly, I do not know. I can't I don't know. I'm not sure, to be honest with you. I don't know about the insurance over there. So I only know about the stuff here in the United States, to be honest with you. So I don't know if they'll cover you there. So you have to do your due diligence to find out. I can't really answer that question. I'm sorry.
I mean, can I stay from here and apply for an insurance company over there in USA? I know I can apply for insurance here, but can I stay as a foreigner and apply for insurance? Would they allow that? Do you know?
I'm not an insurance agent, so I personally don't think so. I think that you do have to be a U.S. citizen in order to get insurance here. There is an application process and you do need to be approved. And so I think that if they find out that you are living in another country, they'll deny the application for your policy.
Even if I'm using the trust to apply for the insurance, they wouldn't.
Yeah, because even if you're using the trust, it's based on the insured if you get approved or denied. So even if you apply for an insurance policy with a trust, if the person who is insured, if they're not healthy enough and if they don't pass the health screening, then they get denied and they don't get insurance.
Oh, okay.
So there are qualifications.
Thank you.
You're welcome. Thank you for asking that good question. Next, I think is Kelsey. Hi, Kelsey. How are you?
Hi, how are you? Thank you so much for all the gems. It's absolutely lovely.
Thank you.
I was just curious, for someone who doesn't have a family, children or a husband of my own and a small family myself, how would you recommend going about starting a trust, or is there a certain time in which you would wait to continue to add those people? Because as you stated, one person cannot hold all of those separate roles.
Okay. So do you have assets or do you plan on acquiring assets? Because I always tell people, if you plan on acquiring assets, meaning you plan on buying a house or you plan on getting a policy or anything like that, then you want to actually create the owner before you acquire the assets. Right? So you want to create the owner of the insurance policy, right? And so that's not going to require you to have a family or, have beneficiaries. You also want to create the owner of, the house that you're planning on purchasing, or if you already have that house. And you have to also think about it in this way. If you were to die tomorrow, and you had, $10,000 in the bank, who do you want that $10,000 to go to? Is it a sibling? Is it a parent? Is it a cousin? Because you can always switch out your beneficiaries. You can create your trust and not have beneficiaries, but I don't advise for you to do that. There's somebody, right, that you could put, and then you can later remove them and add new people and things like that, right? As the trustee, you can make any type of amendments that you need to make. But the best practice is, one, for you to create the owner of whatever assets first, and then two, have, put yourself in the position to where you have this trust estate and you have it already created before you even have the company, right?
That makes sense. I've also heard that not necessarily naming a person as the beneficiary, but yet another estate or trust, as you kind of talked about with the separate trust, so that it does never really expire. Is that something you go over as well?
Yeah, you can. So you can have the grantor be an entity. You can have the trustee be an entity, meaning like an LLC or another trust, and you can have the beneficiaries be an entity as well. So if you wanted it to be an entity like another trust or a business or anything else, you can do that.
Awesome. Thank you so much.
You're welcome, Kelsey. Thank you for asking that good question. Hi, Robert. Wait, is it Robert next? Yeah. Hi, Robert.
Hello. As far as creating bank accounts for these trusts, do we stay away from the banks we already have accounts with to remain private?
Yes, thank you for asking that question. So the best practice is for you not to create your trust bank account with a bank that you are already dealing with personally. And that is to protect you from commingling funds, as well as protect you from having the bank merge your personal profile and record with your trust account.
Gotcha. Thanks.
You're welcome. Hi, Isabel.
Hi. Sorry, I had to unmute it real quick. I have a son that doesn't have a social security, and he's pretty much a free man, so to speak. I don't know if you already talked about this. I kind of barely joined because I was making dinner. Can a non-citizen create a trustee? Because I know you mentioned before a U.S. citizen you have to be a U.S. citizen to create a trust.
No, you don't have to be a U.S. citizen, and you don't have to be a U.S. citizen to be a beneficiary. So no, when I was talking about being a U.S. citizen, I was specifically talking about like an insurance policy. But anybody can create a trust, and there's no requirements for you to have a Social Security or an EIN or any of that stuff. So your son can be your beneficiary without having any of those things.
Okay. So it would be done the same way as you explained with those documents?
Yeah, absolutely. You're just going to name him as the beneficiary, and he's going to have or be a holder of the trust certificate units.
Okay, got it.
All right. Thank you, Isabel.
Thank you.
You're welcome. Do I have any other questions?
Yes.
Yes.
Go ahead. Sorry.
My question is, you mentioned copywriting under common law. How is that done?
So there's like no, so the process, I don't know if there's a specific website or not, but you have to understand that, through common law, you can operate, freely, right? So I'm not sure if there's a certain website, because when we think about copyright, we think about the public route. We think about, going to, and I'm not familiar with the website because I didn't go to it. But you think about the, the trademark website that you have to go to do the copyrights and the trademarking, right? Like through this country. So with the common law, you are able to just operate freely, and it just falls under common law, just like a marriage, right? A marriage, you are married under common law. So you just create your own, entity, your own documentation, but you're not going through the state in order to get married. So you guys are married under common law, but there's no website or place where you go to prove your marriage. So it operates that way.
Thank you. And I appreciate the information tonight. It was fantastic. Thank you.
Oh, thank you so much. I appreciate you. Heidi, you have a question?
Yes, good evening. Can you hear me?
Yes, perfectly.
Awesome. Okay, I do have a couple of questions. I jumped on the call late, so I don't know if you've went over what I'm about to ask. Will there be access to a replay at all?
Yes, I am. Yeah, I'm recording this, so I put it on YouTube, so I can, if you text the number 305-749-9215, then I can send you the replay, the link.
Okay, awesome. My first question, well, I guess my second question, if you still have a mortgage on your home, does it complicate the trust process?
It does not. So so the process when you have a mortgage is you are going to quit claim deed your house over, right? And you can contact your mortgage company. And this is, if you decide to disclose it to your mortgage company, it's optional, right? If you decide to disclose it to your mortgage company that you switch the ownership from yourself to your trust, then what you can do is you can let them know that you want to fill out a form to have the trust be like an authorized user or authorized representative or some type of power of attorney. So every single mortgage company and their process is different. But what you're going to do is you're going to give power of attorney or authorization to the trust to make mortgage payments. Okay. So that's one thing. So now the trust is going to be financially responsible for making mortgage payments. The second thing is that there's something called a due on clause sale, meaning that if you transfer the ownership from one person to another, then the entire mortgage is due. But because you transferred the property from your personal name to your trust, and it's not really a sale, right? You didn't really sell your house, you just gifted it to your trust. Then they created an act. It's called the Garner-St. Germain Act. And with that act, the clause is not activated. So it doesn't trigger a due on clause sale for your mortgage because you put your property under a trust.
Okay. Thank you for that. The last question that I have is, I'm working on obtaining a land grant, or some people call it a land patent. Do you recommend doing that prior to the trust, or do you recommend that being in the trust name, if that makes any sense?
So I've heard of land patents, but I'm not familiar with the process. So when you acquire the land patent, what is actually happening? Are you receiving ownership of that parcel? Is that what's happening?
Yes, it's pretty much. I know state by state it kind of operates differently, but for the most part, yes.
Okay. So my recommendation is that you always create the owner before you acquire the asset.
Okay. Overstood. Thank you so much.
And love it. All right. Hey, Willis. Willis, do you have a question?
Hello.
Yeah.
How are you doing?
Good. How are you doing?
I'm doing well. I wanted to ask you if we're the trustee of the trust. Will we need a operating agreement between ourselves and the trust to operate it properly, or you don't need an operating agreement?
So an operating agreement is for an LLC, right?
LLC corporation, yes.
Okay, so it doesn't apply to a trust entity.
No? Okay, okay.
So your agreement is your
The
trust.
indenture.
Yes, your indenture, your governing instrument.
Okay.
That's all you need.
All right, thank you.
You're welcome. Who's next? Life design.
Life design. By Truth. Hi.
Yes, hi, how are you?
Yes, hi, how are you? I'm well, how are you?
Good, I hear an echo.
Good, I hear an echo. Oh, I'm sorry, hold on. Let me move this phone maybe. Is that better?
Yes.
Yes. Okay, so
it actually isn't, but let's go through it.
But let's go through it. Okay, so one thing I wanted to ask you, can you go over that type of trust you said earlier where the same person is the grantor, the trustee, and the beneficiary?
So that's called a living trust.
So that's called a living trust.
So that is when you are
looked at as
an alter ego.
Can you elaborate a little bit more on that? Like, does it have any legal standing, or like what's the complications with that one?
So that the echo is actually disturbing.
The echo is actually disturbing. Sorry.
Can you hear the echo? Okay. Thank you. So, so with a living trust, it is, it's created for the benefit of you and not for the benefits of other people. So you can use it to, to protect assets, if you want to. But for example, if you had yourself as the beneficiary and then maybe somebody else, and you were to pass away, and the beneficiaries decided that, that they didn't agree with the terms of the trust, then it could end up in probate. So it really doesn't protect you as much, because it's seen as an alter ego. So you can end up, one, obviously getting sued. Any and every trust can get sued, but it doesn't have the protections versus other types of trust. So I really don't know like how much detail you want, but it's a trust. It's a living trust for a living being, and it's for the benefit of them. So you are all the parties involved, and you can operate it as a separate entity from yourself, but it's for you. And so it's seen as an extension of you, and it's not seen as a totally different entity or individual like the other trusts are.
Okay, thank you.
You're welcome. Dee, do you have another question?
I do. I have a loved one that's on the call and she can't get her audio to work. So she's texting me to ask her question.
Okay.
She's interested in your services, and she's asking, she was basically in a car accident and she doesn't want them to come after her home. So she wants to put it in a trust so that the attorney or anyone else cannot come after her home. So she's, I guess, inquiring on what kind of trust she should obtain, and then if you could help her with setting it up.
Okay, so yeah, I can definitely assist her. It sounds like if she just wants to put her home into a trust, that she would just use a private family trust, which is to hold whatever assets that she currently possesses. So if she wants to put her property or, or any other type of asset, she could put it into that specific trust. So yes, I can assist her. I don't know if she wants to do it one-on-one, but if she, is available, then, you can contact me. So just, you can contact the phone number, the 305-749-9215. And I will, send over the information if she's ready to get started.
Okay, awesome. She was informed, or I guess maybe she heard that she needed an irrevocable trust. So when you say private family trust, that's not the same thing. That's different, correct?
No, it is. So every single trust, so that's just the name of the trust, right? But the trust has categories. And so with that type of trust, the category is that it's an express trust is written. It's an irrevocable trust, meaning the grantor can't, doesn't have any power. And it's a complex trust, meaning that it's very detailed. And it's a discretionary trust, meaning that you have full discretion as a trustee. So those are the categories that trust falls under. And it's a common law trust. So it's non-statutory.
Awesome. Okay. Thank you so much.
You're welcome. All right, is that it for questions? I know it's 10:33, you guys. I'm sorry that I kept you so late. I try to do this in 60 minutes, but there's so much information that I want to share with you guys. So if you have any questions, you can either text the phone number or you can send me an email, follow me on Instagram, whatever it is that, that your preferred way of communicating if you have any other further questions. And then in the chat, let me see. I will put the website where you guys can sign up for the Wealthy Trustee program, or you could, take a look at the information that's on the website. So thank you guys for joining me this evening, and I hope that you guys are blessed, and I will see you guys soon. Good night. You're welcome. You're welcome. You're welcome. So the replay is going to be on YouTube. Actually, let me put the link to the YouTube so that you guys I'll upload it in like the next 30 minutes. Let's see. All right, I put the YouTube in the chat.
I'm actually on your website right now, and I don't see the 1497 one, only the 997.
Yes, so I don't have it on the website, so I actually have to send you a separate link. So if you send me a text or an email, then I'll be able to send it over to you.
Okay, thank you so much.
You're welcome. All right, good night, everybody. Thank you for joining me tonight.